What are the laws governing joint physical custody awards? Well, for the jurisdiction where I practice divorce and family law, Utah, those laws are found in Utah Code Section 30-3-10, 30-3-10.2, and if the question of joint equal physical custody is an issue, Section 30-3-35.2. Now, the list is long, but I'll cover them here, and I've also provided a link to those same code sections in the comment section of this video, or rather the description section of this video. Here we go. Evidence of domestic violence, neglect, physical abuse, sexual abuse, or emotional abuse involving the child, the parent, or a household member of the parent. Next, the parent's demonstrated understanding of, responsiveness to, and ability to meet the developmental needs of the child, including the child's physical needs, emotional needs, educational needs, medical needs, and any special needs. Next, the parent's capacity and willingness to function as a parent, including parenting skills and also co-parenting skills. And those co-parenting skills would include ability to appropriately communicate with the other parent, ability to encourage the sharing of love and affection, and willingness to allow frequent and continuous contact between the child and the other parent, except that if the court determines that the parent is acting to protect the child from domestic violence, neglect, or abuse. The parent's protective actions may then be taken into consideration. And the ability to provide personal care rather than surrogate care. Additional factors: the past conduct and demonstrated moral character of the parent, the emotional stability of the parent's inability to function as a parent because of drug abuse, excessive drinking, or other causes. Whether the parent has intentionally exposed the child to pornography or material harmful to minors. The parent's reason for having relinquished custody or parent time in the past, if at all. Duration and depth of desire for custody or parent time, the parent's religious compatibility with the child, the parent's financial responsibility, the child's interaction and relationship with step-parents, extended family members, or other individuals who may significantly affect the child's best interests. Next, who has been the primary caretaker of the child? Don't get me started on that one. Other factors: previous parenting arrangements in which the child has been happy and well-adjusted in the home, school, and community, the relative benefit of keeping siblings together, the stated wishes and concerns of the child or children, taking into consideration the child's cognitive ability and emotional maturity, the relative strength of the child's bond with the parent, meaning the depth, quality, and nature of the relationship between the parent and the child. The disability significantly or substantially inhibiting a parent's ability to provide for the physical and emotional needs of the child at issue, and whether the psychological, physical, and emotional needs and development of the child will benefit from joint legal custody or joint physical custody, or both. Next, the ability of the parents to give first priority to the welfare of the child and to reach shared decisions in the child's best interest. Co-parenting skills, including the ability to appropriately communicate with the other parent, ability to encourage the sharing of love and affection, and willingness to allow frequent and continuous contact between the child and the other parent, except that if the court determines that the parent is acting to protect the child from domestic violence, neglect, or abuse, the parent's protective actions may be taken into consideration. And whether both parents participated in raising the child before the divorce, the geographical proximity of the homes of the parents, the preference of the child if the child is of sufficient age and capacity to reason so as to form an intelligent preference as to joint legal custody or joint physical custody, or both. The maturity of the parents and their willingness and ability to protect the child from conflict that may arise between the parents. The past and present ability of the parents to cooperate with each other and make decisions jointly. And finally, any other factor the court finds relevant. If joint equal physical custody of a child is sought, then these are additional factors also considered in addition to the others I just covered. Is equal parent time in the child's best interest? Has each parent been actively involved in the child's life? And has each parent effectively facilitated the equal parent time schedule, or can he or she? Each parent's demonstrated responsibility in caring for the child, each parent's involvement in child care, each parent's presence or volunteer efforts in the child's school and at extracurricular activities, each parent's assistance with the child's homework, if that applies, and the child is going to school, each parent's involvement in preparation of meals, bath time, and bedtime for the child, each parent's bond with the child, the geographic distance between the resident of each parent and the distance between each residence of the child's school, and the child's school, each parent's ability to assist with the child's after-school care, the health of the child and each parent, the flexibility of each parent's employment or other schedule, each parent's ability to provide appropriate playtime with the child, each parent's history and ability to implement a flexible schedule for the child, physical facilities of each parent's residence, and finally, any other factor the court considers relevant.
you.